Every single week, over $56 million is quietly taken from workers in just 3 U.S. cities.
Yeah,
And like not by masked robbers or, sophisticated cyber hackers, but by their own employers.
right.
And the craziest part about this massive ongoing heist, the system essentially just lets it happen. Welcome to the deep dive. We know you, as a listener, are exactly the kind of person who, well, you love to peer behind the curtain.
Oh, for sure.
You want to see how society actually operates, past the slick PR and the official handbooks. So today, our mission is to explore this massive, sometimes completely shocking chasm between what the rules say on paper and how they actually play out in real life on the streets.
Right, and we have a really fascinating stack of sources to get through today. I mean, we're looking at urban wage theft reports, studies on police discretion, environmental compliance platforms, and even like philosophical legal debates.
Yeah, it's a lot. But to really set the stage for everything we're going to look at today, we need to introduce a foundational concept from legal theory first.
Yes. The difference between de jure and de facto.
Right.
So de jure basically refers to the legal recognition, like the law in the books. It's what the statute says, permanently printed in black and white.
The official rule.
Exactly. De facto, on the other hand, is the factual reality, the law in action. It describes the practices that actually exist in the real world, totally regardless of what the official text demands.
So, I mean, just to clarify, de jure is the speed limit sign saying 65, and de facto is everyone on the highway actually driving 80 because they know the police won't pull them over.
That is a perfect everyday example. And, this tension isn't some new discovery. Over a century ago, legal scholars started pointing out that there are really essentially two justice systems.
Wait, really? A century ago?
Yeah. Back in 1910, a scholar named Roscoe Pound wrote this famous piece called Law in Books and Law in Action. He was looking at the rapid changes of the Industrial Revolution and realizing that the rigid laws on the books were just completely failing to manage the messy, chaotic reality of modern life. That observation actually sparked the entire movement of American legal realism.
Okay, let's unpack this. Because taking that theoretical concept, de jure versus de facto, and applying it to the modern workplace is where this gap hits the absolute hardest. We're not just talking about abstract philosophy here.
No, not at all.
We're talking about people's actual livelihoods.
We really are. We can look at some incredibly rigorous research from the National Employment Law Project, or NELP.
Right.
They conducted a landmark survey of frontline workers in 3 of the largest cities in the U.S., Chicago, Los Angeles, and New York. Now, the de jure law, the official rulebook, says that workers are unequivocally guaranteed a minimum wage, time and a half for overtime, and mandated meal breaks.
But I'm guessing the reality on the factory floor or, behind the retail counter looks completely different.
The de facto reality is staggering. The researchers found that 26% of the workers surveyed were paid below the legally required minimum wage in the previous work week.
Wait, over a quarter of them?
Yeah. And these were not trivial accounting errors or like missing a few pennies. 60% of those workers were underpaid by more than $1 per hour.
I mean, that is a massive chunk of a low-wage paycheck. If you're barely making minimum wage, losing over $1 an hour it's devastating.
It gets worse when you look at longer shifts. Of the people who worked over 40 hours, a massive 76% were denied their legally required overtime rate.
76%? How does that even happen mechanically?
Well, the mechanisms vary. Sometimes managers literally manipulate time cards, or they casually ask employees to clock out, but, finish cleaning up the shop. The de jure law says the shift is over, but the de facto reality is just unpaid labor.
Wow. So if it's this bad on an individual level, what does that look like when you add it all up across a whole city?
So when you aggregate those individual violations across just Chicago, Los Angeles, and New York, the researchers calculated that it results in $56.4 million per week in wage theft.
Over $56 million every single week, drained directly from the pockets of low-wage frontline workers.
It's immense.
And looking at the data, this burden does not fall equally across the board, does it? I mean, we should make it clear to the listeners that we're strictly reporting the researchers' findings here, not taking any political stance, but the demographics are pretty stark.
Yes. The researchers emphasized that vulnerable populations bear the brunt of this enforcement gap. For instance, childcare workers, people we literally trust with our most precious family members, experience an astonishing 66% minimum wage violation rate.
That is just wild.
And the data also highlights stark racial disparities. According to the findings, African American workers experience minimum wage violations at 3 times the rate of white workers.
I want to pause here because there is a narrative that often pops up when people hear these statistics.
Right.
The immediate assumption is usually that this kind of rampant wage theft is exclusively happening in, like, shady, under-the-table jobs or tiny mom-and-pop shops that are just desperately struggling to keep the lights on.
That's a huge misconception, yeah.
Exactly. Because looking specifically at the source data, nearly 1 in 6 workers at large companies, meaning businesses with over 100 employees, also faced minimum wage violations.
Yeah.
When you have corporations with HR departments and massive legal teams openly bypassing the de jure law, I have to observe that ignoring the rules has seemingly become a calculated business strategy. It's not an administrative accident.
Which leads us directly to the most critical question.
Yeah.
If wage theft is happening on this massive industrial scale, why doesn't the government just step in and enforce the rules?
Right. Why doesn't an inspector just show up and fix it?
To understand the mechanics of that failure, we really have to look at the work of Michael Lipsky and his concept of the street-level bureaucracy.
Right, because the people enforcing the laws aren't faceless, omnipotent institutions. They are human beings.
Exactly. Lipsky points out that public policy isn't actually made by legislatures drafting bills or executives signing them. True policy is made by the daily, ground-level actions of teachers, welfare workers, and police officers.
The people on the ground.
Yes, these are the street-level bureaucrats. And Lipsky identified that these workers operate under 2 crushing perpetual conditions. First, a chronic shortage of resources, and second, an elastic demand for their services.
Okay, let's define that second one. What makes the demand elastic?
Essentially, the need will always expand to consume whatever resources are available.
Oh, I see.
If you open a brilliantly funded, highly efficient public health clinic, the lines won't disappear. Instead, people from neighboring districts will start driving there because it's so good. The demand stretches to overwhelm the supply.
That makes a lot of sense.
Yes.
Reading through Lipsky's analysis, it sounds exactly like a triage nurse in a chronically underfunded emergency room.
That is a brilliant way to look at it.
Like the de jure rule is that every patient gets comprehensive, immediate care, right?
Right.
But the de facto reality is that the nurse literally cannot treat everyone. So to cope with the immense stress and, frankly, the moral injury of failing people, they might subconsciously start deciding that certain patients don't really want to get better.
Or that certain injuries aren't that serious.
Yeah, exactly. Just to justify rationing the care. They aren't doing it out of malice. They have to build a psychological defense mechanism just to survive their 12-hour shift.
If we connect this to the bigger picture, it completely reframes how we view the system. The people stamping forms or investigating labor complaints aren't inherently bad or lazy. They are individuals trapped in a bureaucratic structure that has ambiguous, often conflicting goals.
Right. They're just trying to keep their heads above water.
It is mathematically impossible for them to enforce every rule. The system itself forces them to prioritize expediency and survival over principle and thoroughness. So the de facto law basically becomes whatever the exhausted bureaucrat has the energy to enforce on any given Tuesday.
Which is deeply unsettling when you think about it. I mean, it's one thing when we were talking about processing welfare paperwork or checking wage logs. But what happens when we shift the conversation to physical force?
Yeah, the stakes get much higher.
Exactly. What happens when we give that same exhausted, overwhelmed, street-level bureaucrat a badge and a gun? I want to look at the paper by legal scholar Wang Yao on police discretion. Because when you dive into the case law, police have near total discretion over who they investigate and who they arrest.
The legal precedents here are just fascinating. There is a case cited here, Garvey v. Australian Federal Police. A citizen actually tried to force the police to investigate alleged wrongdoing.
And what happened?
The court firmly ruled that police cannot be compelled to investigate a case. Their discretion to do absolutely nothing is fully protected by the de jure law.
So they can just say no.
Yeah.
But it's not just the power to ignore things.
Right.
It's the power to actively target.
Yes. Wang Yao's paper details the very dark side of that same discretion. Look at the case of R.V. Fortesque. Police used the incredibly vague legal standard of reasonable suspicion to effectively detain and question youths outside a nightclub before any actual crime had occurred.
So the subjective, on-the-spot judgment of the officer functionally became the law in that moment.
Exactly. And the research points out that this discretion heavily impacts marginalized groups. Again, just looking strictly at the data presented in the legal scholarship.
Right, the deployment statistics highlighted in the paper really bring this to life.
They really do. The research focuses on Wilcannia, an indigenous Australian community. The police-to-population ratio there was heavily concentrated at 1 to 73.
Wow, one officer for every 73 people.
Yes. Now compare that to the general state average, which is 1 to 459. The data illustrates how discretionary deployment creates a de facto reality where certain communities are policed exponentially heavier than others. When there are more officers on the ground, they inevitably find more minor infractions to penalize.
And that leads to the abuse of tools that were supposedly designed to help people, right? Like FCANs, the field court attendance notices.
Yes, FCNs were legislatively designed to allow police to skip formal custodial arrests for minor offenses. The de jure goal was noble: keep people out of the detention system, just give them a notice to appear in court.
But that's not how it played out.
Not always. The paper cites DPPV Carr, where this discretion was really abused. An Aboriginal man was criminalized via an FCN merely for using profanity that subjectively offended a police officer. The tool was intended for efficiency, but the discretion allowed it to be used for personal vindictiveness.
But wait, let me push back on this for a second. Isn't discretion supposed to make things more fair?
How so?
Like, a cop deciding to let a teenager off with a warning for a broken taillight instead of ruining their life with a criminal record and compounding fines. We want police to have a heart. How does it flip so easily from being a vital tool of human mercy to a weapon of systemic abuse?
That's the core issue. The legal analysis points squarely to the lack of judicial review and public transparency.
Oh.
When discretion is exercised in the dark, when a street-level bureaucrat does not have to explain why they chose mercy for one person, and the maximum penalty for another bias inevitably fills the void.
Because no one is checking their homework.
Exactly. And this is being compounded by new technology. The paper discusses how police increasingly utilize secret algorithms like the Suspect Target Management Plan, or STMP.
How do those algorithms actually work? Like, what are they measuring?
They look at past data, previous interactions, neighborhood demographics, known associates, and they generate a risk score to decide who the police should preemptively target.
A literal risk score.
Yes. But the public has absolutely no right to see the criteria. It creates this vicious, self-fulfilling feedback loop. The algorithm sends police to a neighborhood. The police use discretion to issue more notices. That data feeds back into the algorithm, and the loop just tightens.
The de jure law demands equality, but the unreviewed de facto discretion allows for unchecked discrimination, which is now just baked into computer code.
Precisely.
So what does this all mean? If police can just legally choose not to enforce certain laws, and we know from the employment data that labor laws are broken millions of times a day without consequence, do unenforced laws simply cease to exist?
That is a profound philosophical question, and it brings us to the legal concept of desuetude. We have a source from a Law Stack Exchange discussion that delves into the mechanics of this.
Desuetude.
Yes, it's the legal doctrine arguing that a law becomes entirely invalid through a long, continuous habit of non-enforcement.
Like a law getting an expiration date just based on sheer societal apathy.
In theory, yes. However, as the legal experts point out in that discussion, in the United States, this defense almost never actually works in court. Yeah, courts hate this doctrine. Because if apathy overturned laws, the legal code would just become a popularity contest. You cannot usually stand before a judge and say, well, nobody else gets arrested for jaywalking, so you can't arrest me.
So it's a dead end. You can't ever use it.
Well, not entirely. There is one major exception. Desuetude can effectively function if a high-ranking government official officially and publicly states that they will not enforce a specific law.
Oh, like a formal announcement.
Right. The prime example cited is United States v. Laud. Think about the modern reality of federal prosecutors publicly stating they will deprioritize state-level marijuana laws. If the government formally promises not to enforce it, you can sometimes rely on that in good faith.
Which creates a massive headache for lawyers attempting to explain this to the public.
Oh, it really does.
It actually segues perfectly into our source on the not legal advice culture. This entire de jure versus de facto gap is why lawyers are absolutely terrified of you relying on informal legal information. It's why every legal blog, podcast, or video starts with someone aggressively stating, I am a lawyer, but I am not your lawyer.
What's fascinating here is the fundamental disconnect in how we communicate about the rules. When lawyers speak generally to the public, they are forced to focus on the broad de jure rules.
The textbook answers.
Yeah. But in the actual practice of law, the exceptions often matter far more than the rules themselves. The liability is just immense. If a legal professional inadvertently establishes an attorney-client relationship, they become legally responsible for the advice they give based on your specific context. They can be sued for malpractice or even disbarred.
It makes complete sense. I mean, it's like taking a hand-me-down appliance left on the curb.
How so?
Well, you take it as is without guarantees. If that toaster catches your kitchen on fire, you can't sue the guy who left it on the sidewalk. But applying that to the justice system is wild. The entire legal system is essentially telling us results may vary based on your personal street-level bureaucrat.
Yeah.
The law isn't an absolute guarantee, it's a probability.
Results may vary is perhaps the most accurate, if cynical, description of the de facto legal system. And the disparity in those results becomes incredibly obvious when we look at who has the power to bypass this gap entirely.
Yes, let's talk about corporate navigation versus global mobility, because we really need to compare how massive multinational corporations handle these complex laws versus how human beings crossing borders have to handle them.
It's a striking contrast.
Let's look at environmental regulations first. We have data from the vComply platform noting that U.S. manufacturing CO2 emissions are projected to hit 4,860 million metric tons by 2025. The laws governing this, like the Clean Air Act and the Clean Water Act, are mind-bogglingly complex.
The complexity is staggering, and the penalties for violating them are severe. So how do corporations survive this de jure labyrinth?
They just throw money at it.
Essentially, they buy technological armor. They utilize environmental compliance management systems, or ECMS. Imagine a massive factory pumping out emissions. Instead of relying on a human inspector with a clipboard or street-level bureaucrat, this software automates the tracking.
Oh?
It monitors sensors on the exhaust pipes, alerts operators before thresholds are breached, and functionally guarantees compliance in real time. It protects their brand reputation flawlessly.
Wait, isn't it a good thing that corporations are buying software to ensure they don't pollute? Like, why are we framing environmental compliance as a bad thing just because they can afford it?
Oh, the compliance itself isn't a bad thing at all. We absolutely want clean air and water. The issue is the profound inequity in the experience of the law.
What do you mean?
Corporations can purchase a system that perfectly aligns their operations with the de jure law, entirely shielding their profit margins from the chaos of the de facto reality. They literally buy a VIP pass past the street-level bureaucrat.
Okay, I see. Now, contrast that corporate technological armor with the reality of human mobility. I want to bring in Magdalena Koch's brilliant concept of mobile law.
Yes, this is a crucial piece of the puzzle.
Kamak points out that we use vocabulary itself to build walls. We use the word mobility for desirable movement like, university researchers, wealthy expats, or tourists. But we use the word migration for movement that we want to control, police, and generally view as an inherent security threat.
The language literally frames the legal response. Law acts as the infrastructure of that wall. It can speed up movement for some, like the temporary protection directives that rapidly facilitated the movement of Ukrainian refugees.
Right.
But it can brutally stop others, as we saw with the total border closures during the COVID-19 pandemic. And Kamak introduces this really powerful mechanism she calls embodied law.
Embodied law.
Yes. As you travel, you don't leave the law behind in a courthouse somewhere. You carry your legal status inside your very physical being. Oh, wow. So it's attached to you, like functioning as your own walking VIP bouncer or your own ankle monitor, depending on who you are.
Exactly. For example, look at Article 18 of the European Union Charter. It guarantees the fundamental right to seek asylum.
Okay.
That is the de jure law, written in the highest human rights texts. But the de facto reality at the actual physical border checkpoint is violently unequal. Whether you are granted that right, or whether you are turned away, detained, or worse, often depends entirely on the physical passport you hold in your pocket.
Or, quite frankly, the color of your skin.
Precisely.
Here's where it gets really interesting to me. It feels like we're looking at two completely different realities occupying the exact same planet.
Yeah.
Corporations can literally purchase sophisticated software suites to guarantee they stay in the pristine de jure safe zone, completely avoiding fines and friction. Meanwhile, a human migrant physically carries the heavy, subjective weight of a de facto border inside their actual body, totally subject to the whims of a tired border guard who is making a street-level triage decision. It's deeply unfair.
Are we engineering a society where only the wealthy, whether that's a billionaire or a massive corporation, can afford to actually experience the law exactly as it's written?
The contrast is just stark. The de jure law increasingly functions as a luxury good, while the de facto law is the unpredictable, often harsh reality imposed on everyone else who can't afford the compliance software or the elite legal representation.
Wow. So, to bring this all together for you listening at home, the law is clearly not a dusty, static book sitting passively on a library shelf. It is a living, breathing, and highly subjective daily practice.
Oh, absolutely.
It is carried out by exhausted, underfunded clerks making split-second triage decisions, by police officers projecting their own subjective suspicions on a street corner, and increasingly by incredibly complex corporate software designed to navigate the friction of the rules. The gap between the rules on paper and the reality on the street is where human life actually happens.
This raises an important question, though, a look toward the future. As we increasingly rely on artificial intelligence and automated algorithms to manage these massive systems, whether it's the hidden risk assessments of the STMP algorithm deciding who the police should target, or the ECMS software perfectly calibrating corporate pollution, are we finally closing the gap between the law in books and the law in action?
I mean, babes.
Or, more terrifyingly, are we simply taking the flawed, biased power of the street-level bureaucrat and handing it over to a black box algorithm? Because if we do that, those arbitrary decisions and prejudices become permanently hidden in the code, entirely immune to any human review.
Oh, man. That is a heavy thought to leave off on. But it brings us right back to where we started. The next time you see an official rulebook, whether it's an employment contract, a city ordinance, or just a sign on the highway, well, remember to ask yourself, who is actually enforcing it, and what the street-level rules really are, because the game is always shaped by the reality on the ground. Thank you so much for taking this custom deep dive with us today. Keep questioning the rules, and we'll see you next time.